I can tweak it here, tweak it there. I think that folks in your position have demonstrated the kind of vision, the kind of foresight that really demonstrates, in my view, what it means to be human, and really carries the mantle of progress for our civilization and, frankly, our species into the future. If it weren't for smart people with good ideas and the energy and passion to execute on them and make them happen, we'd still be, living in caves and banging rocks together. So thank you very much for being an entrepreneur, and I hope that in some way I can help you continue your agenda. So I'm going to blow through some legal issues for startups. I think that legal issues for entrepreneurs are something that needs to be relayed to you in kind of a Goldilocks fashion. And by that I mean it can't be too simple or it's not terribly useful, but by the same token it really can't be overladen with heavy detail and minutia. And you'll find, I have found in my experience, that a lot of times when my noble and honorable brethren and sisters on the bar present legal issues to clients, they tend to kind of over-detail the presentation. And it's not that those details are unimportant, because many times the win or the loss in a legal matter is a question of great subtlety. No, it's just that as a functioning entrepreneur, you need to know just the right amount about a lot of different subjects. And you really don't necessarily need to be an expert in too many of them. You've got enough to worry about every day. You've got financial issues, employment issues, labor issues, deals that you're doing, trying to raise money, not to mention the core operation of your company. So I try to tune this presentation to be kind of just a sweetener, just a little bit of, hey, these are some things you need to think about. And really what that comes down to is these are things that at some point you need to discuss with your lawyer. I once tried to do my own plumbing. I once tried to change a sink in my bathroom, thinking, I'm an MIT-trained software engineer. How hard can it be to do a little plumbing? And so, 16 hours and 4 trips to Lowe's later, I realized, I probably should have paid the $200 and just called a plumber. And that's kind of how I feel about lawyers. You can use LegalZoom. You can get by for a little while using sort of do-it-yourself approach with legal work, but at some point it just makes sense from a risk perspective as well as a monetary perspective to just stop wasting your time trying to learn too much about the law and go ahead and hire an expert to get it done for you. Now, obviously, I'm biased. That's what I do for a living, and certainly your mileage may vary, but in my experience, it tends to be more efficient to go ahead and at some point get a good lawyer by your side. All right, so this is legal issues for startups, and legal issues for startups falls generally under this little brand that I've been promulgating over the past few years called Ideas to Money. Don't mean to be crass when I use that brand name. The point is that's really the two endpoints of entrepreneurship, the two endpoints of business. You start with an idea, you go through a whole bunch of machinations, and at the end of the day, hopefully you make a little money. And that's really what entrepreneurship is all about. So here are the legal issues. Why do we care about legal issues? Why can't we just exist and do our operations and sell our product and just not worry about the law? After all, we're all law-abiding people. We're not going to do anything wrong. Who would want to sue us, or what government organization would want to come after us? We're going to keep our nose clean, and we're not going to have to pay attention to anything like that. Well, in my opinion, legal issues are the right problems on which to focus. Here's why. You have many things to attend to during your day, as I say. But the fact that you exist as a company and the things that you perform as a company are only enabled by this substrate of legal laws, procedures, and precedents, rules and regulations that sort of give you effectively the right to do the things that you're doing. A company is not a natural thing. It's not something that exists in nature. It's something that we have all agreed to sort of create as a fiction. And the government effectively gives you the right to operate as a company. So without the law, without attending to legal problems, you don't really have a basis for the legitimacy of many of the things that you do. If you've seen me present before, you know that I really love to make fun of this poor woman from the Roanoke Times in 2004. Name withheld, age 35, a Bullitt Avenue resident, worries about the effect on her unborn child from the sound of jackhammers, and apparently not from the cigarette that she's holding in her right hand. Someone I might suggest who is paying attention to the wrong problem. A lot of things will distract your attention during the day as the CEO of your startup. You'll get ego issues. You'll get personality issues. You'll get things that break. And some of these things require your attention and some of these things don't. The legal issues are always going to be things that require your attention because in many cases, paying attention to the legal issues will either reduce the amount of risk that you operate under or increase the value that you're creating, or at the very least, impose a measure of predictability and reduce the sort of chaos in your company. So legal issues are always something that it's important to pay at least a modicum of attention to. And here's what it comes down to, okay? It's all fun and games till someone loses a lawsuit. And that's really the end point of any legal discussion. Are you doing something that if you do it wrong or are perceived to have done it wrong, is that going to subject you to some measure of legal liability? Is somebody going to sue you? And if they do sue you, are you likely to lose that case? And so every business function that you engage in at some point needs to be thrown up on the wall and see if it sticks to too much risk. And if so, then you need to retune your behavior to make sure that you're conducting yourself properly. Okay. And here's really what it comes down to. This is one of the funniest things I've ever seen on the internet, by the way. Those were the droids you're looking for. This is the stormtrooper from the first Star Wars movie, Episode 4, when Obi-Wan waves and says, "These are all the droids you're looking for." Yeah, this is the guy later that day. Damn it, those were the droids. Look, you don't want to live with regret. Okay, I'd much rather live with failure than the regret of not having tried. It is true. I think that failure should be a badge of honor in our community, and if you try and fail, that's much better than not trying at all, and I would regret not trying. But the kind of regret I'm talking about here is, thinking of the legal issues in your company as kind of an insurance policy. You can drive around your car without insurance, and 9 times out of 10, maybe 99 times out of 100, you'll never get in an accident. You'll never have to worry about not having insurance. But that one time, boy, the downside risk is so dramatic that it just makes sense to go ahead and have the insurance the whole time. And that's what legal issues are all about, okay? Not paying attention to them has such an enormous potential cost that it's just smarter to go ahead and pay attention to the legal as you go about your business. Okay, have I sufficiently made the case for paying attention to legal issues? I hope so. The first thing I'm going to cover is corporate formation. You all need to form a company. You all need to conduct your business within the confines of some kind of corporate form. Why is that? Because if you are operating in business and you don't form a company, then you are personally engaging in these business activities. And if you do something that subjects you to some measure of legal liability, you will be personally liable for that. And your personal assets, including your bank account and home and garden, will be subjected to being attached and paid out as damages if you lose that case. So we form corporations to shield the assets of the owners so that only the corporate assets are at risk when the company inevitably gets sued or fined or what have you for doing something that it shouldn't have done. So that's the primary reason we form a company. Form early and form, well, let's just start with form early. If you're engaging in business activities, you've got to form a company. There's almost no point at which it is too soon. Go ahead and form your company today if you haven't already. Because if you're out there sailing the stormy seas of commerce, you're gonna find you're gonna hit a bad wind once in a while. Not everything always goes well. Hope for the best, but by golly, plan for the worst. And you don't want the worst to happen when you're sailing out there by yourself without a corporation or an LLC around you to protect you and shield you. So the minute you start engaging in business, you really ought to be doing so within the confines of your company. So that's why I say form early. And I say form often, obviously a bit tongue-in-cheek, but to the extent that it makes sense to you to have separate companies to surround separate business functions, you may consider forming more than one company. This is not right for everybody. Most people are perfectly okay to go ahead and just form one corporation, one LLC, and conduct all their business activities within the confines of that one entity. In fact, if you have some idea in your head that you need to be forming 1 or 2 or 3 companies in order to house, your operations on one hand, your intellectual property on the other hand, or that there's some, a big structuring that you want to do in your corporate holdings so that one company does this and then it sells the product to another company and the other company does that. Well, there may in fact be legitimate reasons for doing that, but in my experience, probably not. Okay, in my experience, you're probably overcomplicating your life, you're probably overcomplicating your business, and you're probably overcomplicating the presentation that you're going to make to investors. Simpler definitely is better when it comes to corporate structure. But I do say form often, just on the off chance that there is a reason to throw a different company around different asset classes. And sometimes this will make sense, for example, if you were operating a fleet of cabs, let's say. Well, cabs definitely do get in a lot of car accidents, so it does make sense to put every cab in its own corporation so that really the only asset at risk would be the cab itself and not the entire fleet. So if you are in a situation like that, it may make sense to have more than one corporate entity formed, but for the most part, it probably does not. Another situation where it comes up is when there's some intellectual property. There's a patent, there's some technology, maybe there's some confidential information that has more than one application. So it might work in the automotive silo over here, and it might work in the agribusiness silo over there, and it might work in some other area, pharmaceuticals. And so you would form a holding company, and your idea would be to license the intellectual property out to the various operating entities separately. That may or may not make sense at some point in your maturity, in your growth. Again, from an investor's point of view, you really need to walk a fine line between how complex a presentation you're trying to make, how much you're trying to accomplish all at once, versus a very simple presentation. Hey, we're building this technology. We think it works really well in the automotive business. We're going to dominate that silo first. If it comes to pass that we succeed, then we'll move on to agribusiness, then we'll move on to pharmaceuticals, and we'll form separate entities and restructure at that time. I think that's a better presentation personally to make to investors than, hey, we got 14 companies, and we're going to do all these license agreements, we're going to run all of them simultaneously, and there's just not a lot of people that can carry that off. So, okay, but the real takeaway here is, for God's sakes, get a company in place. Now, what kind of company should you form? If you are a solo practitioner at present, if you are a one-person company, if you are the sole shareholder, it is less risky for you to form a corporation in Florida than it is for you to form an LLC. There is some very weird but recent esoteric law on the books in Florida which suggests very strongly, in fact, that a one-person LLC may not provide a strong enough liability shield for the single shareholder. That is, maybe you may be able to pierce the corporate veil of an LLC to get at the sole shareholder's personal assets. This has not been tested very much yet, but it is it was part of a holding in a case that came down a few months ago, and it's got everyone a little nervous. And so if you are a sole shareholder, in my view, you should form a corporation instead of an LLC. If you are a sole owner of an LLC today, do not panic. You probably don't need to go convert to a corporation instantly. Why? Because if you're going to start to succeed, you're probably not going to be the sole shareholder forever. You're probably going to have an investor or a partner or a co-founder or something. And as soon as you have another member of your LLC, then the concern that I'm expressing about the veil-piercing risk will diminish. So don't think that you need to run out and convert your LLC to a corporation. If you haven't formed yet, I personally like corporations. For most, every startup company that's going to have sort of standard operations, I'm a fan of the corporation, the corporate form. It's centuries old. Everyone understands how it works. There's centuries and decades of good law on the books that dictate to us how corporations work. LLCs, relatively newer, 20, 25, 30 years old now. But really, it's slightly more flexible, the LLC. You can tune it to your liking. But there, in my view, look, bottom of the line is there's really not much you can do with an LLC that you can't do with a corporation. You will hear that it's more expensive to operate a corporation, and the sole reason people tell you that is because you have to do an annual meeting, and you have to paper the annual meeting in your minute book. Big whoop. We do that every year for tons of clients, and it might cost them $20 or something like that. So there is a little bit more administrative overhead with a corporation than an LLC, but frankly, it's trivial. I'm hearing some microphone action. Is someone looking to raise their hand, Mike?
Yeah, somebody was asking the question, C Corp versus S Corp.
Yeah, okay, so so I was just about to get to that. There are, so a corporation, a standard C corporation, is taxed as a separate entity. So if it makes money, it is taxed on its income. And then if you pay yourself or take a draw, you will probably be taxed on that as your income. There are accounting ways for that to be effectively washed out because your income is an expense on the corporation, and so that'll wash out of the corporate taxes. But you've got this double tax issue, which can overly complicate your life early in your company's history. So many companies take what's called the S election with the IRS, which is the small entity election, which causes the company to be treated as effectively a non-taxed entity, causes the company not to be taxed on its own income. The income or loss experienced by the company, realized by the company, is passed through to the owners of the company, who then report that income or loss on their own personal tax return in proportion to their ownership in the company. The same thing is true of an LLC. An LLC can be taxed just like an S corporation. That is to say, it can be disregarded, and its income or loss will pass directly through the company to the shareholders, who will realize that on their return, on their personal return. So you avoid that sort of double tax accounting issue with an LLC or an S corp that you get when you have a C corp. Look, the standard in Silicon Valley today is that you form a Delaware C corp from day one, and expect to be a big, fat, ugly company someday that's going to go public on the New York Stock Exchange or the over-the-counter or what have you. And so you don't mess about with forming a California corporation. You don't mess about with forming a Florida corporation. You just go ahead and form a Delaware on day one, because it's Delaware C corps that go public, not Florida LLCs. Well, okay, that's all well and good. We're not in Silicon Valley, and we've got limited budgets, and so we need to pay a little bit of attention to what all that's going to cost. It's far less expensive for you to go ahead and form a Florida entity than it is for you to form a Delaware entity, especially because if you form in Delaware, you're then a Delaware company, and you've got to pay the annual fee in Delaware, which is a couple $100. But then you've got to qualify to do business in Florida, because you are, in fact, operating in Florida. So now you've got to pay the Florida Secretary of State their pound of flesh as well, which is $120 or $200 a year as well. So now you're sort of double paying both states. It just, in general, tends to be a little bit too much administrative overhead to go ahead and bother to form in Delaware as a first order issue. And my recommendation is that you go ahead and form in Florida. And when things start to get big, and when you've got investors chasing you down, and you're putting your $3 million in the bank, yeah, we'll just move you to Delaware at that point. So the bottom line here is, form yourself a company. Unless you're doing something like a real estate investment trust or some other sort of special purpose entity, my position is go ahead and just form a Florida corporation, take the S election with the IRS, and you got yourself a nice S corp that you can use here in Florida. Now, there are a number of events that could take place that will cause the corporation to lose its S election status. One of which is the most common one by far, is that all the shareholders of the company must be American human citizens. That is to say, you cannot have any foreign shareholders from other countries, you can't have any alien shareholders from other countries, and you can't have any corporate or commercial shareholders. All the shareholders in the company must be human beings, not entities, with a couple of exceptions like certain family trusts and that sort of thing. But for the most part, what that means is, as an S corp, you can't take venture capital without busting your S election, because most venture capitalists, indeed many angels, will invest in you through some investment vehicle, which is probably an LLC or another corporation. So as soon as you have a corporate shareholder, you bust your S election, and you go back to being a C corp for the rest of the tax year, and then for the rest of the life of the company. which is, I admit, one of the advantages of forming an LLC, which is that you don't really bust your, you don't bust your S election because you don't have to take the S election. The LLC is already taxed as a non-taxed entity, as a disregarded entity. So there is a bit of I admit there's a bit of a tension there. If that accounting issue, that taxation issue is important to you, for the most part, as I say, it tends to wash out. And operating as a C Corp is not particularly onerous. So again, my personal preference is that you just go ahead and form a C Corp in Florida. And before I switch to the next subject, are there any more questions on corporate formation? And Mike, I'll wait for you to give me the green light.
You guys have been unmuted. If you have questions on the corporation status, this is a great time to ask them. Sushi's asking a question about tax.
No question is out about.
Sushi, you asking a question about tax?
Hi, Brent.
Hi, Sushi.
Can you guys hear me?
Yes, now I can.
Yeah. For a C Corp, so if I invest in I know as an LLC, I know I could claim it, and get some of it back. What happens in the C Corp?
Claim what, Sushi?
Claim my expenditure, and because the LLC, it carries through like my personal.
Yeah, well, that's the thing, okay? If you have a C corporation, then your personal expenditures will have to be reported to the corporation, and then the corporation will reimburse you for your personal expenditures, and then the corporation can write off the expense that they covered on your behalf. Okay? So that's as I say, that does complicate the accounting issue somewhat, which is why taking the S election for a corporation is generally a good idea, because you can just pass through those tax items the same way that you can with an LLC.
Right. Okay. All right. Thank you.
Okay. Yeah, my pleasure.
This is John's question. In terms of taking the tax deductions on an S Corp, is it related to what percent of the company you own, or how much money you actually put in?
Well, okay. You are entitled to take the income or loss. In proportion to up to the amount of the company that you own, yes. But the loss, mind you, can only be taken against whatever your basis is in the company. So if you didn't put any money in the company, but you own 50% of it, and the company realizes a $100 loss, you don't have any basis from which to take that $50. Okay, unless you put money into the company yourself, at which point that would be your basis. However, if the company earns $100, you will, in fact, realize $50 of income because you own half the company.
Great, thank you.
Now, let me clarify this too by saying, me no tax lawyer. Okay, I know about as much about tax as y'all do if you've been filing a tax return every year. I can form these things, and I can set them up for you, and I can make your operating agreement or your shareholders agreement say whatever your accountant wants it to say with respect to where money goes and how it's taxed. But I am not an expert in the tax law by any means. I'm still here. I'm hearing some background noise, by the way, if anyone's got their mic on. I just don't want to disturb anyone else. Okay, I'm moving to the next subject, and look at us. We're doing pretty good. It's only Hey, it's only 7:30, and we've covered one of the 7 topics. Okay, founder relations. One of the first things you're going to do as a founder of a company is you're going to put a pitch together. And the pitch is to yourself, it's to your spouse, it's to your family, it's to your parents, it's to your children, it's ultimately to your co-founders, it's to your customers, your employees, and of course your investors. You got to be out there in the world with a story to tell that's got some compelling elements, such as, hey, I've solved a really big problem, I've got a great solution, I'm trying to assemble the perfect team, and it's going to be some substantial ROI associated with this endeavor. And that's your pitch, and you're going to have that together, and you're going to be telling it to yourself over and over again. It's going to be the most exciting story, and at some point you're going to convince somebody to come join you. And at that point, you've got a co-founder. And in case the visual doesn't make the point here, it's really important that co-founder relationships be governed by some written agreement. Get this in place early. Don't wait. Don't bring someone into your company with this sort of gentleman's handshake expectation that they're going to be entitled to 30%, 40%, 50% of the equity in the company, with this general expectation that they're going to perform a bunch of activities. Go ahead, sit down, roll up your sleeves, and write this stuff out. Here's what you're going to do, co-founder. You're going to perform this function. We expect to see this kind of result by this kind of date. And write that down, and then get a lawyer to draft either a co-founder's agreement or a shareholder agreement or some contract which governs the company's relationship with you and with your co-founder. There are a number of things you should be thinking of here. One of them is highlighted as sort of the second item here in this list, which is equity vesting. Most of the time when you form a company, if you and I get together this afternoon and say we're going to form a company, you get 50%, I get 50%, and that's just well understood. We work for 2 months, 3 months, 6 months, and then I decide, you know what, I really need to get a day job, so thanks, I'm done now. Got to go. Okay, well, I own 50% of your company, so that doesn't seem fair. One of the ways to prevent that from happening is to vest your co-founder's equity just the same way you would vest employee equity. That is to say, okay, I'll get 50% of the company, you'll get 50% of the company, but we don't get all of that today. Maybe we'll each enjoy 10% a month for the next 5 months. Maybe we'll enjoy 1% a month for the next 50 months. I don't know. Maybe it makes sense to be on a 4-year vesting schedule, but hey, we're co-founders. Maybe it makes sense to be on a 6-month or 12-month vesting schedule. Either way, you want to compensate people for the work that they do, but you don't want to compensate them until they do the work. And this is tough, and these are tough, admittedly, conversations to have. But look, if you're going to found a company with somebody, you're going to be almost as close to them as you are to any spouse. You're going to spend a lot of time together. You may start out as friends, and you may find that at times you don't feel very friendly towards each other. Starting and running a company is an extraordinarily stressful thing to do. It's not all fun and games. And you need to be prepared, as I say, to hope for the best, but plan for the worst. And sit down. If you can form a company with somebody, if you can be that close, that intimate with somebody that you're willing to work with them on a business every day, day in, day out for months and years, then you shouldn't be shy about sitting down and having a tough conversation about, geez, what happens if one of us wants to leave? What happens if one of us gets sick or finds himself under the wheels of a beer truck? What happens if God forbid, one of us gets a drug problem or has a life event that causes us to be distracted and we don't show up to work and we're not getting our job done? What happens in those situations? And we can go over all manner of contingency for that sort of thing, and there are certainly well-trodden paths down that garden. But begin to think about these issues with your co-founders. What if we need more money? Do the co-founders, are they obligated to pull out their checkbooks? What happens if somebody really messes up and commits a crime or commits some kind of fraud or steals from the company? Do we kick them out? If we kick them out, do they get to keep their stock? If they don't get to keep their stock, do we have to buy it from her, or do they just have to give it back to us? All things to be thinking about with respect to how you want your founder relationships. And I can't overstate the case that a written agreement is the best and only way to memorialize your relationships, all of them, not just with co-founders, but with everybody. Written agreements, and I say this as a former computer scientist, written agreements are the code that runs your business. It is the software that runs your relationships. They must be thorough, they must be fault tolerant, and they must accurately describe the relationship that you want to put in place. And sometimes you may find that if you meet with somebody, whether it's a co-founder or a supplier or a customer or a distributor or what have you, you may have a relationship in mind. You may shake hands on it. And you might walk away thinking that there had been a meeting of the minds. And then you circulate the written agreement that you think describes the relationship that you want to put in place. And, excuse me, lo and behold, the other side calls you up and says, I don't know what you're talking about here, but this isn't the deal that I thought we had. And unfortunately, you find yourself in this position of realizing that once you write it down, that's when you realize that you're actually talking about literally on the same page, if you will. That's when you're both singing from the same hymnal and having the same conversation. So sometimes just circulating the written agreement can really help to crystallize the issues that are being negotiated and can suss out ambiguity and misunderstanding. So in all your relationships, go ahead and favor the written agreement as much as possible, but especially with your co-founders. Don't hesitate to have the tough conversations about who gets what when, how do they lose it, and under what circumstances. And I'm going to move on to the next subject unless there are any questions.
Sushi, did you have a question?
And Mike, I'll wait for you.
Hi, Brent. This is Sushi. I have a question.
Go ahead, Sushi.
Can you guys hear me?
Yes.
Okay. How does vesting work once there is outside investment, like angels or VC? So let's say you guys have been working, so you know, for the co-founders, you say, okay, let's vest 4 years, and so we're 1 year into it, and then after the 1 year, you take on investments. Then I know that, so you vested 25%, right? Just between co-founders.
Yeah.
So when you take on investments, usually they will say, well, we want you to vest for 4 years. So what happens to the 25%, or does it start over?
It's fully negotiable, okay? 10 or 15 years ago, it wasn't very fashionable for investors to force co-founders to vest. I dare say it's still not really the norm in Silicon Valley, but it is everywhere else. Investors everywhere else in the country like to come in and cause founders to vest. And it's one of the issues that gets negotiated. And you, as the co-founder, are going to look at this big check that's sitting on the table, and you're going to have to decide what you're willing to give up in order to get that check. And it's, at some point, if you're giving up too many things, that check may not be worth it. And the extent of the, you've already captured 25% of your company, you've already vested 25% of your company, now you're being asked to give it all back and restart vesting. Hey, if that's too painful, don't take the money. Or really push on some kind of different vesting schedule. The investors are investing in you. The investors are investing in the people. Most people who do this seriously and pay attention and are rational, and that's probably a very small subset, quite frankly, but most investors, I think, as a rule, would much rather invest in an A-plus team with a subpar idea than the inverse. They will say, they'll ignore and they won't invest in a really great idea if it's being pushed by less than A-plus people. So they're investing in you, which means they want you to be happy, and it also means that, on the other hand, that they want you to stick around. And they know that entrepreneurs have short attention spans, and they want to make it, want to keep you hungry, and they want to make it worth your while to finish out what you started. So there is a push there to vest founder equity, until some goal is reached or some milestone is reached or some period of time passes. But yeah, you're totally right. You could start out with 100% of your company, and the investor could come in and say, yeah, I'm happy to give you $2 million or $200,000 or whatever it is you need, but here's what's going to have to change about your corporate structure. And then you need to sit down with your advisors and people you trust and decide if those terms are ones you want to negotiate or if that's a check you want to walk away from.
Okay, so it's a negotiation.
Oh, absolutely. Yeah, nothing's carved in stone. Yeah, they can throw a term sheet at you all day and say take it or leave it, but that's just like buying a car. I mean, there's always a deal to be done.
Okay. Also, I have another question, but I'm not sure if you're going to cover it.
Okay.
Splitting for co-founders, splitting the equity, like the percentages and stuff.
Yeah.
Is there a best practice for it, or do you just like?
I don't know that there's a best practice. I think that the passage of time and the progress that the company has made during that time tends to be the best metric for how much of the company a person gets. If we get together for dinner tomorrow and there's 3 of us and we decide to form a company and we all agree that we're going to make equal commitments of time, energy, and money, then it's certainly reasonable for each of us to expect to have a third of that company. If one of us says, no, I need to have 51% because I need to be in control, well, that's fine. But, I may not like that, so I might say, well, I don't want to be a part of that company. Or I might expect that person to contribute a lot more than me if I'm going to be stuck with, 20 or 25% of the company. But however, so after that, after day one, once we formed the company, and we started rolling, the amount of the equity generally that you give up to bring a new person in tends to drop fairly rapidly. It's a fairly steep drop, in my opinion. You might give me 30% of the company to be a co-founder today. But if a month goes by, you've already started a prototype, and you've already started working on sales, you put agreements in place and hired a lawyer and done the things that companies do after they've been around for 30 days, well, shoot, it just doesn't make sense to offer me a third of the company anymore. Maybe I'm only worth 10% at that point. There's no formula. There's no, really nothing that you said best practices. I can't really point you at a document or a guide that would suggest what those numbers look like. I just have a sort of this intuitive heuristic for you, which is that, with the passage of time and the growth of activity inside of the company just gets more valuable. Therefore, the amount of it that you're willing to give up to a new person who comes into the sandbox is just by nature going to diminish. If those things are not true, however, if the company has not moved forward very much, if value hasn't been added to the company in any meaningful way, well then sure, we call that person a day one co-founder, just like the three who went to dinner, and throw 25% at her and expect her to perform just at the same level that we apparently haven't been over the past 30 days.
Okay. Well, I have that question because I've been listening to the Founders Dilemmas audiobook.
Yes.
Yeah. So.
Yeah, look, I mean, you can find war stories in all kinds of situations where people threw 20% at somebody who just wasn't getting it done, and it felt like they should have only given them 5, and there are all kinds of arguments and whatnot, but ultimately these are personal decisions that everybody has to be happy with. You need to own enough of your company to get yourself bounding out of bed in the morning. And listen, I'm going to go ahead, given that it's already 7:40, I'm going to go ahead and kind of keep going through the presentation. We're going to be here till 9 or 10 p.m. I apologize if I'm cutting anyone off, but I do want to get the content out, and then we can see what kind of questions there are after. Okay, investor relations. Again, something very common that you're going to participate in is the searching for investors. At very few times in the law in the United States are you treated as guilty until proven innocent. And I'm being sort of tongue-in-cheek here, but the reason the Securities and Exchange Commission exists is because during the 1920s there were a lot of people trying to sell a lot of useless, worthless stock to the public, and a lot of people got bilked out of a lot of money. And so the SEC exists to prevent you from defrauding people and taking their money and selling them a worthless interest in a worthless company. One of the ways that you prevent yourself from getting accused of doing something like that is by circulating a document to your prospective investors called a private placement memorandum. If you talk to any lawyer in Tampa and ask them how much it costs to draft a private placement memorandum, they will say somewhere between $10,000 and $20,000. And you will say, well, if I had that kind of money, I wouldn't need to go get investors. I state this simply by saying this is the standard. The private placement memo is the standard for what you should be circulating to investors, potential investors. It is a bipolar document in that one of its purposes is to sell the investor on the business plan and demonstrate what a great opportunity this is and how it's going to make more money than nylon rope. And on the other hand, to demonstrate to the investor, potential investor, how risky this opportunity is and how they shouldn't consider investing in it unless they've got money to burn and are prepared to lose everything, because here are the various reasons and risk factors why this company could fail. And so as I say, the document is bipolar, and that it's a sale on the one hand and a warning on the other. The reason the warning is there, however, is to protect you, so that when you do lose the investor's money, God forbid, that when the investor comes a-calling and suing you for stock fraud and claiming that he or she was defrauded into spending that money, you can hold up the private placement memorandum that the investor signed prior to the point that they wrote the check, and you can say, Judge, Your Honor, ladies and gentlemen of the jury, says right here we warned them about all the various risk factors. Now, most startup companies don't spend the money to draft a $15,000 private placement memorandum for their seed round or even their Series A round. They use their executive summary, they use their business plan, they use a pitch deck, and hopefully a lawyer has taken a look at it and put in at least a page in there that says, hey, there's some risk associated with this. Please don't invest in this company unless you're prepared to lose the investment because this is a technology startup or what have you. So I can't tell you that it's risk-free going out trying to solicit investors without a PPM, but a lot of people do it, and it tends to be the norm. Sometimes it depends on the investor. Some investors will laugh you out of the room if you don't come in armed with a full-on half-an-inch thick private placement memorandum. Finally, what is it that you're selling? Are you selling an equity interest in your company, or are you selling a debt? One of the reasons that you will want to sell a note or a debt in your company is because when you sell equity in your company, you put a valuation on it. And there are only so many ways to value a startup company. One of them is book value. What are its assets worth? Well, probably not much, because it probably doesn't have any. And what perhaps are its trailing 12-month revenues multiplied by some mysterious multiple that we pull out of the air, which is probably an integer less than 7, depending on market conditions. Well, hard to do that as well, hard to compute that if you don't have any trailing 12-month revenues. So it's really difficult to put a valuation on a startup company during its early months. If it is a technology startup and it's got a pretty cool idea, chances are it's worth $1 million or $2 million or $3 million. But we don't know. That's just kind of what we tend to expect. The fact is, when you sell equity to an investor, you are effectively making a market in the securities of your company, and you are setting a valuation on it. At that point, if you sell me 10% of your company for $100,000, congratulations, you are effectively a $1 million company. But you see, it may not make sense. It may be difficult to ascertain how much of your company you should be selling for how much money, because the market has no knowledge about what your company is worth. So it may behoove both you and the investor, just go ahead and take the money as a loan. Don't sell equity. Don't give them 10% of your company. Just give them a loan. Give them a note that says that you'll pay them back the money that they gave you with some interest rate. Maybe you can give them a convertible note. Maybe you can give them a note that says, yeah, we'll pay back with some interest rate, but if we don't, or if we choose not to, we will convert your debt, the debt that we owe you, we'll convert that to some portion of equity interest in our company at such time in the future when we know what that equity is worth, because perhaps by then we will have taken some kind of institutional venture capital round, or we will have some significant revenues on which to base a corporate valuation calculation. So sometimes we, in the early stages of the company, will sell a convertible note instead of selling stock in the company. Again, this is a negotiable issue. This is something that will come up in investor negotiations. You may go out with an offering circular of some kind, whether it's a PPM or just a pitch deck, and say, yeah, we're looking to raise $100,000 as a convertible note. The investor may say, I don't want your silly note. I want to buy equity in your company. Fine, let's do it. Let's have that conversation. Let's have that negotiation. Let's figure out if there's a deal here to be done. And again, in the interest of time, I'm just going to move on. But I do want to, the takeaway point here is that you've got to be careful when you're going out talking to investors. Please only talk to rich people. Try not to take money from people who can't afford to lose it if your company fails. Employee relations. Again, I don't know if you remember this guy. This was the guy who jumped out of the JetBlue plane because occasionally employees just get crazy. Written agreements with all employees, from the janitor up to the senior vice president in charge of wombats. Written agreement. It is the best way to enjoy and measure predictability on your relationships. I'm going to talk about policies before fraternization. Have a series of policies in place for your employees. Have an employee handbook. Have a policy on sexual harassment and what happens when somebody complains about it. Have a policy on social media use and what you can and cannot do on Facebook and LinkedIn when you're carrying the mantle of the company and you're acting under the company's brand. Have these policies because they are important and they will help you win lawsuits when you get sued for doing things that you haven't done. Fraternization. Unfortunately, as an entrepreneur, the only other human beings you're ever going to see are the people you work with. And from time to time, human nature will take you down the course that it is naturally going to take you. And you'll want to start dating your coworkers. Look, if you can avoid it, don't. It's just fraught with risk. The minute you have to fire somebody who you've been dating, believe me, you're going to be hearing from some angry lawyer somewhere. It's just generally, if you can avoid it, it's just generally a good idea to try to stay as, keep your nose as clean as possible with respect to how you treat your employees. And I say this with a touch of sadness because it's unfortunate that our world has evolved legally to the point of such a litigious society that folks can't be human beings around each other anymore. But there it is. You'd just be foolish to try to bend those rules too much. And again, in the interest of time, I'm going to move on. Customer relations. I don't know if you've seen this woman before. If you get on one of the stock photo sites and query happy customer, this is one of the pictures you get. You may have seen her on other websites. Fear not, I am an intellectual property lawyer, it turns out, and I, in fact, have a license to use this photograph here in this presentation. Your point as a business is ultimately to maximize shareholder wealth. That is to say, to make a lot of money for the people who invested in your company, including yourself. But I claim that a focus on shareholder wealth, on maximizing shareholder wealth, does not maximize shareholder wealth to the extent that focusing on something else does, and that something else is happy customers. If you focus on making your customers happy, I claim you will make greater wealth than if you focus solely on wealth maximization. And there are a number of reasons for this, and if you Google me, you can see a YouTube video I did for TED a couple of years ago called Ideas to Happy, which was all about focusing on customer happiness, employee happiness, world happiness, what have you, as a profit maximization strategy. Okay, just real quick, if you're operating on the web, go ahead and have a terms of service, go ahead and have a privacy policy. Put these things on your website, and they will be binding on your customers to the extent that they are reasonable. That is to say, if you put a terms of service on your website that has a prominent link to it somewhere on the bottom of the screen where they typically are, and that will be a legally binding contract, and it will govern your customers' use of your website. So go ahead and think through what your terms of service should say. Recognize that you do owe your customers and everyone else with whom you come into contact a great service of security that you can't be terribly careful. You can't be too careful with personally identifying information. And to the extent that you are in any way collecting my name, my email address, my financial information, my credit card number, be very, very careful about how you handle those things, and recognize that numerous laws will apply to you from numerous states in the United States and numerous countries around the world. If you have a breach or you lose that data, you will have numerous obligations of compliance in terms of informing your customers and that sort of thing. So be very, very careful about that. Recognize, of course, that if you're putting a product into commerce, you really got to have an insurance policy. Any product, I don't care how simple it is, could suffer a defect in design, manufacturing, or delivery, so as to render it dangerous to the customer. If you're putting products into commerce, you will eventually be sued for product liability. Please, for the love of God, have some insurance policies in place to cover you for those scenarios. Intellectual property. I, as I say, have been practicing intellectual property law alongside corporate law for the past 20 years or so. It is a subject that's very near and dear to my heart. In fact, I have written a book on intellectual property law for you and others like you, for the entrepreneur. It's called Ownability, and it is just coming out of design right now, and hopefully will be available to purchase for download, or maybe even free at some point off BrentBritton.com, and I'll keep you all posted there. Intellectual property is the core of your company for the most part. You have inventions, you have works of authorship, you have secret confidential information, and you have brand names and logos, and all of these things are governed by intellectual property law and can be protected. Again, well-written agreements must be in place that transfer ownership of intellectual property from the people who create it to the company itself. And why do I stress the word people? Because only people actually create things. And I don't care if they're an employee or an independent contractor or a co-founder or your grandmother. I want to see a written agreement in place that transfers ownership of that person's intellectual property from them into the company. Otherwise, the company doesn't own it. And if I'm an investor, more to the point, I'm investor's counsel or buyer's counsel 2-3 years down the road, and you're selling me a company that's based largely on intellectual property assets, I am going to audit the ownership of that intellectual property back to Adam and Eve, because you need to demonstrate to me that you own your intellectual property assets. Intellectual property ownership is subtle and weird and counterintuitive and can often be done wrong. And so written agreements must be in place with every person who's creating intellectual property for the company. It's a first order of business. A quick example, if you come to me and say, hey, build me a desk, and we shake hands, we don't have a written agreement. I build you a desk and I sell it to you and you give me a check. Everybody in the world, including the courts, would agree that I can keep the check and you own the desk, and that's it. That's the end of the deal. However, if you come to me and say, please create for me a work of authorship or some work of intellectual property, in general, for the most part, we don't shake hands, we don't have a written agreement. I create the photograph for you or the written work or what have you, and I hand it to you and you hand me a check. Well, I own the check and I still own the work that I gave you. Because we don't have a written agreement, ownership does not pass. In many cases, we have to have very magic words in the agreement, words like specially commissioned work made for hire or what have you. My point here is that if you are a company and you are buying intellectual property from other people, perhaps people overseas, perhaps people who are independent contractors, perhaps people who are creating the very family jewels that will form the basis of your company, you need to have a very solid written agreement in place with those people. Otherwise, you do not own exclusively the work that you're buying from them, and they can sell it to your competitor tomorrow. Are you scared yet? I hope so. Please be very, very careful about buying intellectual property and the results of and proceeds of people who work on your intellectual property without getting written agreements in place. If you are inventing, you should think. Hello? Okay.
I think you're good. You're
if
good.
you are inventing new technology of some kind, you should be thinking about protecting those inventions with patents. If you have a brand name, and I bet most of you do, you really ought to think about getting both a state and federal trademark for that brand name. If you're creating works of authorship, written agreements, literary works, photographic works, what have you, you should be thinking about registering copyrights. And if you have a lot of secrets that give you value in business, then you need to learn a little bit about trade secret law. Building your intellectual property portfolio is something that your investors are going to like. In many cases, they are going to expect it. Investors like it when you tell them, hey, we are doing this cool new thing, and guess what? We are obtaining the right and attempting to become the only entity in the country that can do this thing by virtue of our patents. Investors like market exclusivity. They like barriers to entry. So consider paying a lot of attention to what intellectual property you might have and how you might protect it. And finally, the third bullet here. Be very, very careful about what comes into your company, okay? Your employees may come to you someday and they may say, we copied this stuff from the internet and we put it in our product and that we're about to ship, but it's okay, it's a fair use. Or it's okay, it's open source. Or it's okay because everybody does it. None of these things is necessarily a fatal condition, but the question to be answered is much more subtle than it's okay, it's a fair use, or everybody does it, or it's open source. There are many more details to be considered there. So be very, very careful about using assets from outside your company that are not invented within the four walls of your company, because they could subject you to substantial liability. And again, just because it's approaching 8 o'clock, I'm going to move forward to the final legal point, which is tell the truth. Okay? We will forgive you in this country if you do something wrong. For the most part, we don't mind whatsoever if you make a mistake, as long as you stand up, raise your hand, and say, yeah, that was me, that was my foul, sorry. The minute you lie about it, however, we begin to dislike you most greatly. You probably all remember, what's her name? The woman who had the show, and Martha Stewart. Martha Stewart went to prison a few years ago for insider trading, didn't she? No, she did not go to prison for insider trading. She was, in fact, guilty of insider trading, but that's not why she went to jail. She went to jail for obstruction of justice, because when the FBI or the SEC, or whoever it was, the Department of Justice, came to interview her about her insider trading, she said, nope, I did not do that. That was not me. And so, having lied to a federal officer, Martha Stewart went to jail. So telling the truth is just a really good way to keep your nose clean, to stay out of trouble. When something goes wrong, if you have a breach of security, or I'm hearing a voice. Okay. If something goes wrong, you know, you got to admit it to especially if it puts anyone in danger. You got to admit it to the public. You got to warn people. You got to let them know that you've lost their email address or their bank account number or what have you. You know, engaging in false advertising, making false claims, this stuff will get found out and it will kill you in the marketplace. Disparagement, don't say things about other people that aren't true. If your competitor puts out a substandard product and you can back that up with data, go ahead and say that. But don't make factual assertions about your competitors or anyone else that are true, or you will get sued. Okay, and that is my sort of 40,000-foot flyover some of the legal issues that you need to be thinking of if you're going to be an entrepreneur. Is this list exhaustive? Obviously not. There are many more things and other things that could apply to you based on what's going on in your day-to-day, but I hope that this was at least instructive to you that there are many things you need to be thinking about in the legal arena. And I thank you for your time, and I'm happy to take questions.
Good job, Brent. Bravo.
Great.
Yeah,
Thank
great
you.
job.
Okay,
Most kind.
Anthony, you had a question first?
Yes, thank you. Good evening, Brett. My question is this. I'm a designer, and I designed let's just say I designed a banner for a baseball stadium, right? And I took a picture of it,
Okay.
and I wanted to put it in a book that I'm selling.
Okay.
Since I was able to purchase the banner, right, or have a copy of the banner myself and take my own picture of it, do I need to get the approval of the stadium to use it in a book?
That's a really good question, Anthony. My first answer to you would be a question: do you have a written agreement with the stadium?
No, I don't have a written agreement. I own the rights to it. I own the copyrights and everything to it.
Then I would generally feel very safe in saying that you can do whatever the hell you want to do with that content. Unfortunately, the stadium made the classic mistake, which I referred to earlier, which is they took intellectual property from you without obtaining rights to it. Now, do they know, understand, and appreciate the perilous position that they are in? Probably not. Are they going to be inclined to send you a nasty letter or even sue you if you put their banner in a book? Possibly. So I can tell you all day long that you'll win the case because you don't have a written agreement, but it may in fact be that you don't want to deal with having to fight the case in the first place.
Right.
So it may make sense in this instance to go ahead and ask those guys, hey guys, you don't mind if I have a certain portfolio right to this work, do you? You don't mind I'm writing a book. Obviously it's not going to compete with you. It's not going to, I'm happy to drop a footnote that says this is the picture as it hangs in such and such stadium, thanks to them. You can certainly do that. Call them up and make sure they're okay with it. And then let them know if they're not, that, well, I can kind of do this anyway, guys, because you don't have a written agreement. And at some point they will talk to a lawyer and they will figure out that you are right and they are wrong.
Okay, perfect. Thank you so much.
My pleasure.
I have a question.
Is that Sushi?
Guillaume, you were talking about having an agreement between co-founders.
Yes.
What would you recommend once we define the agreement? I mean, with regard to having a lawyer reviewing it. I mean, who should
yes.
be addressed to?
Yes. Generally, I, as outside counsel, for example, to the company, will write the founders agreement on behalf of all the founders, circulate it amongst them. They will sort of, talk amongst themselves and come to me for a certain amount of guidance. Ultimately, however, if enough money is at stake, every person involved should at that point have potentially their own personal lawyer pay attention to their own personal rights. And it may be a situation where you get, 2 or 3 lawyers at the table hashing these things out. But generally, if you're at a point where you're about to form a company with somebody, you can generally agree on things that apply equally to everyone without every individual person getting their own lawyer.
Okay. And what should be the expense? I mean, with regard to a lawyer to check that.
Say again, please.
How much should we expect to pay if we go to a lawyer to get to review an agreement between co-founders?
So that's really going to depend on a number of factors. Legal advice, for the most part, is not cheap. I myself charge $450 an hour. Many lawyers in Tampa who do very good corporate legal work charge anywhere from $200, $250, $300, up to $550 or so. Some lawyers will work with you with respect to maybe deferring payment of legal fees for some period of time. are taking a measure of equity in the company instead of legal fees as cash. But any agreement that you're doing that's worth anything is going to be, a couple $1,000s. A couple $1,000 is 4 or 5 hours of my time, for example. I can write a pretty good agreement as a first draft in that amount of time. Maybe even a second draft, maybe even a telephone conversation. But it does tend to add up. I'm not gonna pull that punch. You've got a lot of legal work to pay attention to as a startup company, and it's not uncommon, especially if you're doing a couple of patents, for your legal budget for your first year to be well into the 5 digits, $20,000, $30,000, $40,000, depending on your particular circumstances. So, if you call up a typical corporate lawyer in Tampa and ask them to look at your co-founders agreement, they're probably going to spend an hour or two at it. They're probably going to charge you somewhere between $500 and $1,000, and that would probably be on the low end. If there are a lot of issues that need to be redrafted, negotiated, hemmed and hawed back and forth, then obviously that adds up based on how much work is being put into it.
Thank you.
And sorry to be the bearer of bad news, but.
Hi, this is Mike. Can I ask a question?
Go right ahead, John.
Hi, I have 2 questions. Number one, how do you protect yourself from hiring a developer who's worked on some proprietary software in this former company and now comes to your company and you're hiring because of that knowledge, but you want to make sure he's not taking any intellectual property from his former company?
You put that very clearly in the contract, in the written agreement that you sign with that incoming employee or contractor, and you contractually obligate that person to not do that. You say that they absolutely will not share any confidential information, they won't breach any agreements that they're currently bound to, that they won't inject anybody else's property into your company, and if they do, they will indemnify you and the company and your company for any lawsuit that may befall you, and that you will force that person to pay for your defense.
Great.
So we make that very clear in the agreement.
Okay, my second question is, can you ask an employee for his former confidentiality agreement that he signed with the other company?
Yeah, you can ask. You can certainly make it a condition of employment that you get to read important contracts that they've signed. They can decline, and then you have to decide if you're willing to go forward, or not. They can also, if there's a provision in the prior agreement that they might consider embarrassing for whatever reason, perhaps they could give you a redacted version of the agreement that has one provision or another blacked out. For example, if somebody left a company and they're entitled to some kind of severance package or something like that, they may not want you to know what that dollar figure is. I wouldn't have any problem with that employee blacking out that particular, whiting out that particular figure, say. But yeah, sure. For the most part, you can satisfy yourself that with respect to the agreements that they've signed, departing from prior employees.
Guys, let me just follow up real quick. Oh, go right ahead.
Yes, thank you.
Good.
Somebody else had a question? Was that you, Jesse? Nobody else? So if you're seeing my screen right now, on the Startup Biz Best Practices, there is a whole bunch of templates. A lot of the things that Brent alluded to, such as, employee policies and finance agreements, PPMs, founder agreements, lots of those templates, and I stress that they're templates, not to be used as is, are on the site. And then there are also some good sites like DocStock and Company Lawyer, which are listed here for you, which will give you at least a sense of what you should be thinking about. And so one of the ways to minimize the expense, you need an attorney. You should have Brent or somebody like Brent look over these things, is to look at these templates, and apply whatever you can to your own situation. So if you're looking at a co-founder agreement, for example, Sushi or John, get a template and write out the best one that you can with the language, and then take it in to Brent or someone and say, all right, what are we missing? And so at least you have a starting point.
I actually, Michael, I think that's a great strategy. Let me just interject real quick. I think that even just reading through those documents can give you a sense of what the issues are. And so before you even bother to pay a lawyer, do go out there and look for as many of these templates as you can. I mentioned I try to keep this to the sort of Goldilocks zone so that we don't go into too much detail. But at some point, the tension is how much money do you want to pay on lawyers versus how much time do you want to spend becoming your own expert in these issues. It's definitely worth a pass through these documents, either the corpus of information here on this site or DocStock or what have you, LegalZoom even, to go out there and just read a few of these and get a sense of what they say. You may find that 20, 30, 40% of them make absolutely no sense to you whatsoever. That's our fault. That's the legal crap that has to go into all these documents because over the decades we've decided that it all needs to be in there. But the real substantive issues, again, what happens when an employee leaves? What happens when a co-founder leaves? Do you get their stock back? That kind of stuff. That will really educate you as to what your agreement should say.
Yeah. Yeah, if you can walk in with one, I've done that before in Seattle in the companies that I've had, and oftentimes my attorney would say, I can't make much improvement on this. This is pretty darn good. I'd suggest a adjustment to this clause or that clause, and you save yourself a bunch of money. Other times I've walked in with what I thought was a good template, and it was horribly flawed, and it took some reworking. But at least you have a starting point. And as Brent said, all of the issues or most of the issues that should be included in these agreements. So help yourself to the template.
I just want to add there that there are some of us tend to be more sticklers for this stuff than the other. As a former software engineer, I'm very, very particular. I'm anal retentive about very few things. I'm one of the most relaxed individuals you'll ever meet. But I'll tell you, your contracts need to be crystal clear. They need to be internally consistent. The language needs to be well written. They need to be grammatically correct. And here's why. At some point, if it matters, that contract is going to be read by a judge and the jury. And that jury is going to be populated by my Aunt Tilly and your Uncle Bob, okay? And these are folks who don't know you and don't know me and don't care, at all about what great people we are. All they have is the contractual language to decide who is right and who pays a big check. And so that contract needs to be easy to read, and it needs to be clear. And that's why you'll write your own contract or find a template on the internet. You'll bring it to a lawyer, and if the lawyer's worth anything, many times they'll say, yeah, there's a lot of red ink I got to put on this thing to get it into shape. Don't discard that advice lightly, because the lawyer, the contract lawyer, is trying to protect you against the inevitable litigation when that contract is getting read by people who only have the contractual language to go on to make their decision. I'm done.
Good. Other questions? Covered a lot of territory tonight. Lots of issues. But these are the kind of issues that will make or break your company.
I just want to say thank you, Brent.
Someone was saying something, but I didn't quite catch it.
That was me, Sushi. I was just saying thank you, Brent. That was a great presentation.
Hey, thanks. That really means a lot. I really hope that when you stand before, or virtually or whatever, stand before a group of people and they give you your time, I feel like you owe it to them to be a little bit entertaining and hopefully a lot educational. So it's my honor to be in front of you tonight, and I hope you find that it was time well spent.
Excellent.
Hey, Brent, this is Jesse. I've got one quick question.
Go ahead, Jesse.
Yeah. Over time, how would you recommend that we judge people in your position as far as making the hiring decisions or using somebody like you? Like, how do I screen an attorney or a lawyer to look over my stuff and to choose who should be working for me?
Boy, that's a really great question. And the answer, just to bring it, again, in the interest of time, to bring it down to brass tacks, is reputation, reputation, reputation. Talk to their current clients. Ask for references. Don't be shy about saying who among your clientele is most like me. can I call them up and ask them what their experience has been? And typically, the client can give you that name without breaching the attorney-client privilege. Typically, I will ask my clients first before I'll hand their name off to a new client, but let them know, hey, now look, you ask for references. Obviously, the lawyer's going to cherry pick, but I'm probably not going to give you somebody who is known to dislike me. But I honestly, that's pretty much the best way to judge a lawyer, is to talk to their current clients and see if they've provided a lot of value for a fair price. You spend a lot of time with your lawyer. They tend to be a very strategic and critical presence in your life. And so it helps if there's somebody whose company you kind of enjoy. Okay, I'm not saying you go to beers together every night or anything, but you kind of need to speak the same language. It helps if they're the kind of person whose advice you sort of instinctively respect because they have a bit of a, I don't want to say commanding presence, but they kind of convince you that they know what the heck they're talking about. Personally, I think it helps if the lawyer has a set of experiences that are similar to yours. Maybe they've got the same kind of training as you. If you're starting a software company, it might help to have a lawyer who understands software. You maybe wrote it in the past. Speaking of my own experience, if you're starting a record label or a music company, it might help to be, to talk to a lawyer who's got some experience in that area, a number of clients in that area. But that's really what it comes down to. Unfortunately, there's no good, you can look at Martindale Hubbell. You can see how people are rated. You can ask them for their resume and see all their awards and whatnot, but most of us have more of those than we know what to do with anyway. So really, I think it comes down to, you like the cut of their jib, you like what they say, their billing practices seem fair, and you've talked to one or two of their clients, their reference clients, and you've got a good sense that they can do what they say they can do. And with that, gang, it's
this is John.
Yeah, go ahead, John.
I just have one last question. A lot of times when you sign contracts, there's always a dispute as to what state the contract falls under. What advice can you give us in that area?
Well, there are two issues there. One is which state's laws apply to the interpretation of the contract, and secondly, where will we sue each other if we have to? And those aren't necessarily always the same. Sometimes you can agree in a contract that New York law will apply because New York is known to be, more commercial friendly or entertainment friendly or what have you. But that the venue for lawsuits will be here in Tampa. The situation that you're probably thinking of, though, is when you are doing a deal with a Texas company. The Texas company sends you a contract. They want Texas law to apply, and they want the venue to be somewhere in Texas. You want Florida law to apply, and you want the venue to be somewhere in Hillsborough County. One of the ways around that I've used in the past is if we sue you, we will sue you in Texas. If you sue us, you will have to come here to Florida to sue us. And so the venue question is the one that tends to be the most critical, because if you know that you have to go to Texas to sue those guys, you're probably going to be slightly disinclined to sue and more inclined to work things out. And vice versa. If they know that they have to come here to Florida to sue you, to an unfriendly jurisdiction, they're going to be less inclined to sue you and more inclined to try to work things out. And so doing that sort of cross-venue approach tends to reduce the likelihood that there's going to be a heated lawsuit. Ultimately, however, it is a negotiable point, and it does come down to negotiating power. If you've got a big customer or a big distributor that says, no, we're in Chicago, and all of our contracts are Illinois law and Chicago venue, take it or leave it, well, then you've got a decision to make as to how that might affect you. And I have numerous clients who've been affected by that very negatively and refuse to enter into agreements where the venue is not somewhere in Central Florida, and what have you. So that is a negotiable point that does come up from time to time. But I do like that solution that I recommend, that compromise that I suggested, which is if you're suing them, you go there, and if they're suing you, they come here. And on that happy note, I'm going to go ahead and depart, but you have my email address there, at least one of them, on the screen there. You did for a while. Brent.Britton@gray-robinson.com will always work. You can Google me and find my email address all day long. I'm always happy to entertain follow-up questions from this group off the clock as best as I can. If we really get into the nitty-gritty, obviously at some point we need to put a relationship together get a retainer and all that jazz. But if there are follow-up questions, you feel free to send them through Mike or send them to me directly. I'm happy to try to do my best to answer.
Thank you, Brent. That was awesome.
All right, everyone. Have a great night.
Take care.
Bye.
Okay. Okay, that was a lot of great information in an hour and a half, it was spot on from everything that I know. So I hope you found it useful and took good notes. And a lot of it's captured here on the best practices site on Startup Biz. And you also have a bunch of homework related to this that's been posted on Trello. But we do have time for some presentations if anybody wants to pitch their deal and get some feedback from the group. Anybody? All right, then let's talk about everybody pitching next week. I think we're going to have a get-together. Was somebody going to... Yes? No?
Yeah, Mike, this is John.
Hi, John.
Yeah, Mike, this is John. I have my project of the week, and one of these days I'll settle on something. Can I go through it for 2 minutes?
Yeah.
Okay, great. Could you give me the screen?
You bet. John's still trying to figure out what he wants to be when he grows up.
The worst part about that is my wife is trying to figure that out too. Okay. I'm still trying to come up with a concept here. And this week I'm playing around with something called catered takeout. And what catered takeout is, I basically went through the Limelight pitch, and I answered their 4 points. And the question number 1 is, this is how they define giving a pitch. Do you want to serve guests a great meal, but can't afford the caterer? Then select from menus being prepared for the day of your event by local caterers. Pick it up and save 1/3 of the price. What we're basically saying here is that on the supply side, if a caterer is already contracted to produce a certain menu, his incremental cost for generating another 100 dishes of that menu is fairly small. So he could afford to discount that, provided someone is picking it up, and he doesn't have to go through all those services of delivery and setup. So that's the concept. And I just wanted to get any people's feedback on that.
Have you talked to any caterers?
This is Anthony.
Yes, I spoke to 2 caterers so far. I'm sorry. Yes, I spoke to 2 caterers so far, and both of them were thumbs down on it. But one was my wife, who's usually negative on things I say anyway. So I'm going to have this week. This week, I'm going to have to go out and pitch it to a few other people.
Yeah, I would say you need to get their feedback to see if there's enough incremental opportunity there. Anthony, go ahead. You had a question?
No. I was going to ask the same question. Did you talk to caterers?
Yeah,
they tend not, because dealing with a lot of entertainers, I've dealt with a bunch of caterers who do their events, and when it comes to doing extra work, even though it's incremental on the good side, it's all that preparation that is going to impact them on their timeline to deliver their content to the venue.
right. Good question. What I assume here is that they'll have enough notice, at least 2 weeks notice, to increase their project. So if they are preparing something for 100 people and they go up to 200 people, they can basically schedule that with their staff and buy the necessary ingredients. But everybody today is looking for a deal with caterers.
Yes, I agree to that statement.
Yeah. So I'm trying to I'm trying to work on that side of it, that we could basically give a significant discount to people who actually pick up the meals. And that's it. So thank you for your feedback.
Well,
John, have you gone into some of these new stores that allow you to go in and actually make the food, put it in the containers, and take it home for the week? And all? Have you looked into those and learned a little bit about that business model?
Yes, but I'm not aiming there. I'm aiming at someone who's going to place an order for several $1,000s, not just 1 or 2 meals. This is okay, because caterers would not be interested. You know, if you're doing a 200 guest reception, getting another 10 isn't of interest here. But getting another 100 and making it $2,000 to $3,000 more becomes of interest.
Okay, so how would let me understand this. So we're talking about maybe catering a wedding or catering a business meeting or something that's already planned out, and then you're getting quotes that way. Is that what you're recommending then? Is that what you're thinking?
Right. I'll give you a typical case in point. A caterer typically has jobs 1 month to 12 months out. So if he has a job planning that he's going to deliver a salmon meal with these ingredients on May 31st, he basically puts it on the site, describes the menu, and then people bid on it. Okay, but there's a minimum of at least $1,000 bid.
Got it.
John?
Yes.
The only problem you're going to run into is typically people that are wanting catering for the event are going to want, especially if they're going to spend $1,000 or more, they're going to want a certain modification to things. They're not just going to, take a menu and say, okay, that's fine, and pay their money. They're going to want, maybe certain modifications to, a beverage menu or something like that. And from what I understand is this is going to be extra work for the caterer to do, and they're already got their main client, which is paying full price for this food that they have to worry about. And many caterers simply don't want, they've got this event, they don't want to even hear about another event, especially if it's for some, it's for lower than their list price.
Yeah, but what tends to happen is, I'm not talking about beverages here. This is strictly food. Beverages would still be handled by the individuals. And people who tend to want great deals will also tend to buy their own liquor, because most venues make most of their profits on the liquor. So this is strictly food. And I know, like in my wife's situation, if she can double up on a menu for 2 different receptions on the same day, I mean, she's making 75% gross margin when she does that.